Mike Lee's proposal to block judges from appointing U.S. attorneys. In a bold move that could reshape the landscape of judicial appointments, Utah Senator Mike Lee is advocating for a significant change in how U.S. attorneys are appointed. This proposal aims to prevent federal judges from having the authority to appoint U.S. attorneys who serve temporarily while the Senate undertakes its thorough confirmation process. Cami Mundo, a congressional correspondent for the Deseret News, reports on this developing story, emphasizing its implications for national policy, particularly in Utah and the western states. In Washington, D.C., Lee's newly introduced legislation seeks to empower President Donald Trump to make unilateral appointments of interim U.S. attorneys. This would occur while his official nominees undergo the Senate's often lengthy vetting process, which has recently faced significant delays attributed to Democratic opposition. Lee argues that this change would not only restore the president's executive authority, but also eliminate potential conflicts of interest that arise when judges have a say in selecting the attorneys who will present cases before them. President Trump deserves to choose the individuals who will work alongside him, Lee stated. Judges should not have the power to select the U.S. attorney who will be arguing cases in their courtrooms. Just as they would never allow a president to appoint their law clerks. This provision was previously removed by Congress, only to be reinstated by Democrats to obstruct the Bush administration nearly 2 decades ago. It is time to return this authority to the leader of the executive branch. Currently, there are 93 U.S. attorneys serving across 94 judicial districts, all of whom are appointed by the president as political appointees. These nominations must then undergo a series of confirmation hearings and votes in the Senate before the appointee can officially take office. However, this process can be protracted, often taking weeks or even months to finalize. Consequently, the Attorney General is allowed to appoint an interim attorney for a maximum of 120 days, while the nominee is under consideration by Congress. If the nominee is not confirmed by the end of this period, the district court has the authority to appoint a U.S. attorney to fill the vacancy until a permanent replacement is found. In recent months, Democrats have employed nearly every tactic available to delay the confirmation of Trump's nominees, resulting in a significant backlog that may not be addressed until after the August recess. This growing delay has led to the expiration of the 120-day period for some interim attorneys, placing the responsibility on district judges to address these vacancies. While district courts can confirm the current interim attorney to continue their role, there have been notable instances where judges have chosen not to do so. For instance, the Northern District of New York recently declined to extend John A. Sarkozy's tenure as the acting U.S. attorney when his 120-day term ended in July. This decision prompted Attorney General Pam Bondi, who had initially appointed Sarkozy, to exploit a judicial loophole to keep him in the temporary role. In another case in New Jersey, Bondi faced a similar situation when Alina Habba, a political advisor to Trump, had her term expire. The courts appointed a different attorney to take her place, but Bondi later removed this new appointee and reinstated Habba using the Federal Vacancies Reform Act of 1998. These initial refusals to extend interim appointments have sparked frustration among Trump's supporters, which has driven Lee to propose this new legislation. However, the future of Lee's proposal in the Senate remains uncertain, as it would require at least 7 Democrats to break ranks with their party. Meanwhile, Democrats have been utilizing all available strategies to impede Trump's agenda. A challenging endeavor given that they do not currently hold a majority in any branch of government. This situation raises important questions about the balance of power and the role of the judiciary in the appointment process. What do you think about the implications of this proposed legislation? Do you believe it would enhance executive authority or create more conflicts of interest? Share your thoughts in the comments. Daniel Rosen's U.S. Attorney nomination caught in Senate partisan battle. Trump nominee delays. In a surprising twist, Daniel Rosen, President Trump's nominee for U.S. Attorney in Minnesota, finds himself ensnared in a partisan tug-of-war. that could delay his confirmation indefinitely. Initially nominated in May, Rosen's path to the position hit a snag when Senate Democrats, led by Senator Charles Schumer, imposed a hold on all judicial nominees until the White House provided more information about a jet gift from Qatar to Trump. This isn't just a bureaucratic hiccup. It's part of a broader strategy by Democrats to slow down Trump's appointments. Despite bipartisan support from key figures like Senator Amy Klobuchar, who praised Rosen's commitment to the office's tradition of excellence, the procedural hurdles persist. Rosen, a seasoned attorney with a background in civil litigation rather than prosecution, stands out for his lack of traditional prosecutorial experience. Yet, his nomination has been backed by Minnesota's GOP congressional delegation. His journey to the U.S. attorney position has been marked by both professional achievements and political involvement, including his work on eminent domain cases and his active role in Jewish community organizations and GOP politics. The confirmation process has been further complicated by recent tensions in the Senate, particularly over the contentious nomination of Emil Bove for a seat on the U.S. Court of Appeals. This backdrop raises questions about the likelihood of a swift resolution for Rosen's nomination. As the summer recess looms, Senate Majority Leader John Thune has hinted at extending the session to address the backlog of nominations, signaling the high stakes involved. For now, Rosen remains in limbo, with his potential tenure as U.S. Attorney hanging in the balance. This situation not only highlights the partisan nature of Washington politics, but also underscores the impact of these battles on the functioning of key government positions. As the wait continues, the people of Minnesota and legal observers across the country watch closely, wondering when, or if, Daniel Rosen will assume his role as the federal government's top legal representative in the state.